Five biggest mistakes you can make with your IRA. You ready for them? We're going to go through them and you're going to learn something here today because I can almost assure you no one else on YouTube is talking about this the way we're going to talk about here today. So I'm glad you're here. And I certainly hope you get a lot of value out of this one episode. So welcome to the Heritage Wealth Planning YouTube channel, my friends, the place where you come to learn about financial planning in all topics: investment management, tax planning, estate planning, IRA mistakes, and hopefully ways to rectify those mistakes. So if you like what you see here, hit subscribe, hit subscribe, and then hit the bell to be notified for future content because we do a lot of stuff here and you want to keep up, lots of things changing. So let me get out of the way here real quick. I'm going to share with you an article that I've written on my blog. This is probably one of the first two, I guess, I can't remember, but back in January. And this is, where's the blog say? Update your beneficiary designations now. All right. So the first thing we're going to talk about when it comes to the five biggest mistakes is not having a beneficiary designation on your IRA. That is mistake number one. That's the biggest mistake. And I actually just talked about it in an episode I literally just did, about half an hour ago, where we talked about this guy thinking he was going to leave his assets, his retirement assets, to transfer via his will. And unfortunately, the guy who was writing from Market Watch didn't say retirement assets don't it could transfer assets by will, but that's silly. Don't do that. So, and that's the same thing as having no beneficiary designation. No beneficiary designation, or the corollary of that, leaving it to your estate. Now, what that means is when you don't have a beneficiary designation, it does go to probate. All right. Your will have to jump in there to determine who gets your money. Now, a couple problems with that. Remember, probate is just a public proving of your will. That's literally all it is. And so you say public. Beneficiary designations they don't transfer via probate, so it's private. So if you want to leave your money to me, you can. And no one's going to know. Absolutely. If I want to leave my money to you, I can. No one will know. It's literally that simple. All you got to do is say, Josh died. I'm Joe Schmo. I can prove his death with his death certificate, and I prove I am Joe Schmo. Send me the money, and they'll send me the money. It's literally that simple. When you transfer assets via will, again, a will is a public proving. A probate is a public proving of your will. So it has to go through probate, and then that has to be made a record at the county clerk's office or the county probate court. You can find out if you want. You can look up all those probate records right now. You can go down I'm in Fulton County. You can find all the rich people in Fulton County and who they're leaving their money to. You can look up the estate of Elvis. You can do all that stuff. But it's not just Elvis from 50 years ago. It's anyone. You can find those public records. What do you think a lot of life insurance guys and life insurance guys aren't sleazy? I should take that back. But a lot of sleazy guys, what they used to do is look at the obits, and then they go down to probate court and see what the estate was saying. You don't think there's a reason for that? Well, because it's public. They could see, hey, little Janie's getting all this money, and I don't think little Janie has any advisors, so I'm going to jump in there and see if I can't give her some advice on selling stuff. It's just bad. And that's one of the things I used to say with life insurance a long time ago. Let's look at the obits. And start calling people. And I know some people actually had success with that. I could never do that. That seemed a little bit over the top to me, but either way. So not having a beneficiary designation, no one as a beneficiary will make your will, or if you don't have a will, intestate transfer through the probate courts, which is a public of your affairs, as a public reckoning of your affairs. Now, secondly, let's say you just forgot, or you named your estate because you're working at a guy at the bank, and the guy at the bank forgot to tell you you really should name somebody as a human being, and you named your estate as a beneficiary because you just want to get out of his office. You're just like, I can't take this anymore. So you said, okay, whatever, name my estate. Now what happens is when your kids get the money, just using that for an example, they have to delete that account within 5 years. They got 5 years in which to delete that account. Or deplete that account, I guess is probably the better word, deplete or delete, however you want to look at it. That means if you had, $500,000, $100,000 or $500,001, it doesn't matter. But as long they can't have any money left in that account within 5 years. Now think about this. What are the tax ramifications on having to deplete that account within 5 years? They're gigantic. So what you've avoided now and made no one avoid it is their ability for the inheritor, the person who can inherit the assets, to stretch those required minimum distributions over their own life expectancy. I'll just give you an example. I'm 48 years old. I get hit by a bus. Let's say my wife predeceased me and I forgot to name my heirs in my beneficiary designation, or even I've left to my wife. It doesn't matter. I just forgot to name anybody. The recipient of that account will have 5 years in which to deplete the entirety of the account. Now, if I left it to my wife, who's 44, she could stretch that distribution over her life expectancy. Now, she will have to take required distributions, but as a 44-year-old person, it ain't much. And so she can stretch it out over her life expectancy. Now, she can always have access to more if she wants, but she's not forced to take it out within 5 years and pay the tax on that. And that's a big, big issue, especially if you're leaving it to somebody who's working, because now they're going to receive the assets on top of the money they're already making, and they're going to pay huge amounts of tax on it. So we don't want to leave it for those two reasons. We want to name a beneficiary for those two reasons. One, we don't want to take a private asset that will transfer privately and make it public through the estate process, i.e. probate court. Two, we don't want to lose the ability for our heirs to be able to stretch the IRA distributions over their life expectancy. Does that kind of make sense? All right, let me actually bring myself up here a little bit. No reason for that to have so small. All right, two. Well, now the minute I say that, I want to show you what I'm talking about. Old beneficiary. That's mistake number two. And I'm just going to share with you a couple examples. I probably should have kept myself small. All right, so here's my article about updating your beneficiary designations. And I have a bunch of cases where I show you where old beneficiaries really hurt people badly. So widower is disinherited from wife's $900,000 retirement account. Here's a case where a man married to his wife for nearly 20 years was disinherited from her nearly $1 million retirement account because she named her sister beneficiary 4 years before she married this guy. 24 years after naming her sister beneficiary, she dies, and guess who gets the money? The sister did, rightly or wrongly. If the decedent wanted her husband to get her money, she had to update her beneficiary forms. Now, you need to read the article. I got a link for it right here. It's through New York Post. NewYorkPost.com. So this lady had an IRA, and she named her sister the beneficiary because she was single. She gets married, and she's married for 20 years to this gentleman, but she forgot to change her beneficiary designations. When she dies, her husband does not get the money. Her sister does, because the beneficiary designation is cut and dry. Whoever is on the beneficiary gets the money. All right, watch this. Secondly, here are two widows, and this one is from Investment News. Two widows. Each was married less than a year to their respective husbands when those husbands died. One widow is divided survivor benefits under the ruling that because she wasn't married for a year, the company was obligated to give her benefits. The other was granted benefits, overriding the beneficiary form the decedent had filled out, naming the kids as beneficiaries. So all that says there's a lot going on, and I'll go into this. Because the court in this case said that the company specifically doesn't state in its retirement plan document the marriage must be over a year for the surviving spouse to receive the benefits, the surviving spouse must receive the benefits, even the decedent named his kids. So the point about that is your beneficiary designation could have some issues on very limited instances, but the vast majority of the time, I'd say 98% of the time, your beneficiary designation is going to drive who gets what. Now, in this case, this is retirement benefits from a pension, and that has a little bit difference than an actual beneficiary designation. But there are still some areas that you got to be considerate of. And the reason I show you that is not because I say, oh, it shows you don't need to do a beneficiary designation, is because the law is very fluid in regard to who gets what. And you need to be clear, as crystal clear, of how you want your money to go. Because in this case, we have the same exact case. Two cases with two different spouses. One court ruled against the spouse, one court ruled against the kids. So the kids were disinherited. Now, if she simply would have maybe rolled that to an IRA, or she could have named the beneficiary designation as a kids or the whatever, and it would have been easy. I mean, just say, okay, at the end of the day, I don't want to leave this money in my 401k. I'm going to roll it over to my IRA. It'll be outside the company plan purvey, whatever it is, purview. And now I'm going to say explicitly, I want this, that, and the other person to get the money. And it's no fuss, no muss. It's explicit. This is one of the drawbacks we'll leave your 401k plan, actually, because the company supersedes a lot of times what the IRA laws will. All right, so that's another area. Watch this. Decedents, we already talked about it. In this case, okay, this one's pretty open and shut right here. Husband named his wife beneficiary of his retirement account. Husband and wife divorce. Husband does not change the beneficiary, i.e. has an old beneficiary designations and subsequently dies. Plan pays out benefits to husband's divorced wife, even though the daughter of the husband was still alive. Daughter sues and loses in the court because the ex-wife was still named as beneficiary. Really nothing unusual about this one. You don't want your ex to get your money? Update your doggone beneficiary designations. And this one was from, I think, Illinois, Cornell Law Review or something like that. So again, ex-wife, don't want her to get the money. Didn't change your beneficiary designations. That's number two. The number two mistake people make when it comes to their IRAs. They didn't change their beneficiary designations to keep them up to date. So we got number one is not having a beneficiary. Number two is having an old beneficiary. Number three is a wrong beneficiary. I know it seems like beneficiary designation tutorials, but this is what happens with IRAs. I see this all the time. Look, and here, a lot of people that I work with are very big on tithing, or at least leaving money to charities and whatnot, churches, typically hospitals, SPCA or whatnot. And so what I see all the time, I got 4 kids, so I got $100,000 in my IRA. 25% goes to each of my children, and then I'm going to leave $25,000 in my brokerage account to SPCA or the church. Don't do that. That's dumb, because now what you've done is you've actually reduced the amount of money that your children are going to get because they got to pay tax on that distribution from the IRA. Even if they can stretch over their life expectancy, it's still a taxable asset. And so this is the third biggest mistake, is that we're leaving taxable tax assets to individuals when we should be leaving those tax assets to charities. Because if I leave that money to a charity in my IRA, it is not taxed whatsoever. The charity receives it tax-free. The kids don't pay tax on it, and I can leave my non-IRA to my kids or whatever, and they'll receive that money tax-free as well, because what's called the step-up and basis rule. All right, let me bring myself back up. So remember, you have to look at it like this. You take a piece of paper and slide it down in half. In fact, I'd even say slide it in 3 directions, but still, for the time being, you got tax-deferred assets over here, which is your IRAs, taxable assets over here. IRAs, if we're inclined to leave it to charity, they should get some of this money right here for sure. All right, that's just a fact. Non-IRAs should go to your children because they will inherit that tax-free. They will not inherit your IRAs tax-free. So if you're leaving your IRAs to your children, they're going to inherit a tax account. That's all there is to it. They're going to inherit a tax property, and they have to pay tax on it. Where if you left it non-IRA to them, they'd inherit a tax-free property, and they would not have to pay tax. Now, with that said, if you leave your IRA to a charity, they will inherit it tax-free as well. So if you do this properly and we slide it down the road, half and half, you're going to basically make the best of both worlds. Your charity will get it tax-free, and your kids will get it tax-free. Now, obviously, most people have more money in an IRA than they do a tax-deferred account, than they do a taxable account. If that's the case for you, then you just got to plan accordingly. But either way, leave your IRA assets or some of those assets to the charity, not to your kids, to the extent that you want the charity to get the money. I'm going to share with you a story, too. I'll never forget this. I met an attorney, a wonderful guy, old retired Marine Corps, I think he was a colonel, up in Oyster Bay, New York. And he was telling me he used to write for Trust and Estates magazine, which in the estate planning realm is the state trust magazine for sure. And he was telling me that when people leave, and this is just nothing to do with this 5 mistakes, but when they leave a number of their estate, I want 10% of my estate to go to the SPCA. Well, guess what the SPCA does? I mean, the attorney general of that state now is the person in charge to make sure the SPCA gets 10% of those assets. Now, look, I'm not an attorney. I don't know how likely this happens, how often it happens. I don't know. I'm just going off what this old estate planning attorney told me, who used to write for Trust and Estates magazine. And if you knew some of his clients, you knew this guy was not a shrinking violet by any stretch of the imagination. He was sharing me some of the folks he worked with, and you would know them, and I'm not going to tell you, but it was pretty big wigs. So this guy certainly knew his stuff. So anyway, the attorney general has to get involved because they have an obligation to protect the charitable entities that are in their state. So if SPCA says we're supposed to get 10% of Josh's estate because I said that in my will, well, guess what? None of the estate, they're going to have to do an accounting of the estate. To take an audit, they got to make sure all the assets are accredited and accounted for, so that way the SPCA can make sure that they judge my calculator is worth $5 correctly. And how long will that take? I have no idea. So he's told me to tell you, this is 10 years ago since I don't know if he's even alive anymore, but he told me to tell people that if they're charitably inclined, leave the money from charity from their IRA as opposed to a bequest in their will, which says, I leave 10% of my assets to the SPCA. Because in that case, the Attorney General is in charge of making sure the SPCA gets 10% of your estate. And that estate is all encompassing your IRA, your non-IRA, your home, your calculator, and all that stuff. I never would have known that other than meeting this guy and looking over Oyster Bay and seeing Billy Joel's house over there. We had a lot of fun. Good guy. When you learn a lot from talking to people. It's amazing. So just remember that too. That's nothing to do with these 5 mistakes, but I guess it kind of could. I mean, at the end of the day, it could be a mistake. I leave money to charity by my will as opposed to my IRA. So it does fall into that, actually. You want to leave IRA money to your charity. Leave non-IRA money to your kids. Now, that doesn't mean it has to be all separate. You can still say 25% of my assets in my IRA goes to charity, 75% go to my kids, something like you can do that. Absolutely. You can do whatever you want, but just make sure your kids get the non-IRA asset and the charity gets the IRA asset. Okay. Number 4, and I talked about this yesterday or 2 days ago, Estate Planning 101. No power of attorney. Mistake number 4. And I would venture to say 90% of the people don't have a durable power of attorney. Remember, an IRA is an individual account. It's individually owned. I own it. My wife does not own my IRA. I do. My wife has no say in the management of the IRA because she does not own it. She might be the beneficiary. If I die, she takes ownership of it, but she does not have any say or control while I'm alive, or vice versa. I have no say or control over her IRA while I'm alive either. And so what a POA does, a power of attorney, a durable power of attorney, is general power of attorney too, but I'm talking durable power of attorney, because a durable power of attorney establishes my wife can act on my behalf now if I so state it in the durable power of attorney document, but also while I'm incapacitated. And the incapacity is the biggest issue because men in particular get Alzheimer's, dementia, Parkinson's. And if you don't have something that allows somebody else, it doesn't have to be your wife, just somebody to act on your behalf when it comes time to taking distributions and just whatever, just having access to the money, the hoops that person's got to go through, not the survivor, but your spouse or your significant other, whatever, is immense, especially when the most inopportune time because they have to do something, i.e., December 28th, they got to take a required distribution by the end of the year. If they don't, it's going to be a 50% penalty on what they didn't take out. And your husband's got Alzheimer's. He doesn't know who he is anymore. And you've forgotten about the account because it goes directly to him. You just throw it in the shredding bin. And all of a sudden you're like, wait a second. My husband had this big IRA. I haven't taken a distribution out of it yet. So you call over to the bank or whatever. The bank says, I'm sorry, Mrs. Smith, but you don't have any control over the account. You're like, but I'm his husband. I'm his wife. Yeah, that's great. Nothing you can do. You don't own it. But I'm the beneficiary. He's still alive, right? You just said he's still alive. Yeah, okay. Well, if he's still alive, you have no control over it. Yeah. What are you going to do? So you need a power of attorney, a durable power of attorney to solve for that issue. And it could be a crisis for sure. What was the other one I had? I'm drawing a blank on it, but I had some lady, was it right before? Oh, so that's another thing too. I'll never forget. This could be the number 6 mistake. I still got number 5 to do. This will go into number 5. Let's talk about number 5. Waiting too long to take distributions. It just occurred to me. This is a 2-part mistake, actually. It just occurred to me. So while I'm thinking about it, don't take your required distributions at the end of the year. For heaven's sake, take your required distributions at the beginning of the year. I don't understand why people wait for the end of the year. So think about it. You have RMDs. Let's say you're just, you got $1 million in your IRA. You got to take that. The first year distribution will be $36,000. All right. So let's say you got to take $36,000 out. It's December 15th, and you got to take the $36,000 out, and then you die. You got hit by a bus or something like that. The Patriots lost the Super Bowl and you couldn't take it, and you just had a heart attack because you're thinking that guy Nick Foles, which I actually like Nick Foles. But anyway, still you're really upset, and you're like, oh man, it's just over for it. You forgot to take your RMD, your distribution. Well, guess what? Your wife's got to take it, and she's got to get it by the end of the year because you still had to take those RMDs. And if she doesn't get it done, guess what happens? 50% penalty. 50% penalty because the RMD wasn't met. You have to take your RMD. So don't wait in terms of the calendar year to take it December 31st. I remember when I was at USA one time, we had an issue what was it, like in December 30th, and our computers were down or something. I can't remember. It scared the heck out of me. I was like, all these people are not going to get their RMDs on time because the computer's down. They fix it, but I'll never get that. I went home that night thinking this could be bad. And they got it done overnight. They were frantic. Don't get me wrong, it happened. But I was just sitting there thinking, again, if the computer goes down and your firm has a standing order to take out an RMD on the 31st of December, and the firm's computers go down, they can't do it for whatever reason. The IRS doesn't blame the firm, they blame you. You're the one who's supposed to have taken it done. So don't wait until December to take your RMD out. Take it at the beginning of the year. Now people say, but I lose a year of tax deferral. You're losing a year of tax. You still have to pay the tax on the money. The more you defer, the more taxes you're going to have to pay. And on top of that, don't forget, you're switching ordinary income off your IRA to capital gains and dividends, which may be tax-free anyway, depending on your tax bracket. The second part of that is don't wait too long. I can't pause it because if I do, it shuts me down. I'm going to pause it. I'll be right back. I want to show you something. All right, so I showed you this the other day. Let me minimize myself. All right, so this is a fake sample plan of the software I use, and this is from Dustin Tibbetts' Jazz Wealth Nest Egg software, and I use the same thing at Heritage Wealth Planning. It's Right Capital, just I have my little icon up there, but it's pretty good. So anyway, here's our effective tax rate. And now I'm 70 years old, and I got 72. My wife and I, we got no tax rate at all. That's when I should start pulling money out of my IRA. Now, obviously, you have to because of RMDs, but my RMDs at 72 is like 4%. So if I have, $400,000 in my IRA, I'm pulling out 400. That was at $16,000 times 0.04. Yeah, $16,000. So the fact I have no income here, I'm still going to be in a low tax rate. In fact, for $16,000, it was standard deduction of $26,600. That's tax free. And so unless I have $12,000 of other income, I'm still paying no income tax. And even if so let's just say I have $15,000 of other income, $16,000 from my IRA, $15,000 of other income. After the standard deductions, I'm only having taxable income of $4,400. So my tax is going to be $400. So when you adapt these tax brackets down here so low, start pulling money out of your IRA there. Don't wait until you're mandated later on to take more and more and more, because then this is what happens. That's the widow's tax trap I always talk about. That's where I get hit by the bus and my wife inherits everything and she's in a world of hurt. I had a client up in New Hampshire, nicest people in the world, and they had negative income a couple years, but they had a big IRA. And I was like, oh, why were you not pulling money out of this? And I know why, because their accountant wasn't. I love accountants, but accountants are reactive, my friends. They're not proactive because they're so flipping busy when it comes to tax time. It's just hard for them to be proactive. Now, some of them are, I get that, but man, a lot of them are not. They're reactive. In this case, the accountant should have been saying, hey, you got no income, but you have these huge IRAs. And they're only 68 years old. So when we start pulling the money out of the IRA now, well, we have no income because they have literally negative income. And see, 68, they could have easily pulled $24,000 out of the IRA and make it tax free. That means they could avoid this in the future. And that's the number 5B of the risk of your IRA, is waiting too long to pull the money out. Don't just fall at this. Everyone says defer. No, don't defer if you're in a low tax bracket. For heaven's sakes, deferring is good if you're in a high tax bracket today, but a low tax bracket in the future. Don't defer if you're in a low tax bracket today and a high tax bracket in the future, like we're seeing here. That's crazy talk, and yet it happens all the time because everyone is trained to defer. So don't do that. All right, so those are 5 risks to the IRA. 1, no beneficiary. 2, old beneficiary. You got to update them. Make sure their ex-wife or ex-husband isn't on there. 3, wrong beneficiaries. Don't leave all your IRA money to the kids and then your non-IRA or your IRA and then your non-IRA money to the charity. You want to switch it out. 4, no power of attorney. No durable power of attorney in particular, because durable power of attorney means it's a power of attorney that survives incapacity. No. 5, risk number 5, waiting too long to take distributions from your IRA in the calendar year. Don't wait until December to take your mandatory distributions. Do in the beginning of the year. And then 2, don't wait until you're forced to take it out when you have low tax income, usually when you're about 70, 68, 69, 70 in these years right here when the RMDs are low. Hope this helps, my friends. As always, if you like what you see here, don't forget to subscribe and hit the notification bell. And I am going to start saying, go to Heritage Wealth Planning too and subscribe there as well, just because you never know with YouTube. At some point they might yank the channel. And I hate to sound like that, but I was just watching this guy yesterday. He's like, man, who was he doing? He was doing like firearms, just showing people how to correctly load a fire. And I said, man, I can't believe they took that down, because there's a wonderful mechanism on how to get people to learn the proper use of firearms. And YouTube ganks his channel because they don't want to promote firearms. That's fine. It's their channel. We're just sharecroppers. They can do whatever they want. But if he didn't have a way to revisit with his subscribers, then they would have been lost. So it just occurred to me. So just if you are interested in what we're talking about here, go to the blog at heritagewealthplanning.com and sign up there as well. All right, my friends, we'll see you next time. Thumbs up are always helpful. Comments too. And anything you have to say, please put in the comments below. We'll see you. Thanks, guys.